Welcome back to another edition of Between Two Fars. I'm Warneke Miller, and I am joined once again by Judge Reid Prouty from the Armed Services Board of Contract Appeals. He's a vice chairman over at the ASBCA, and he's been talking to us a little bit about sort of avoiding litigation and some pre-litigation issues. But today we're going to shift gears a little bit. We're going to talk about alternative dispute resolution, which is a very, very important aspect of any claim that may be surfacing in your jurisdiction. And really, what can an attorney do to prepare for a successful ADR?
Thanks, Warneke. The easiest answer is simple. Treat it very seriously. Let me go back a little bit. The board loves ADR. Most of the ADR we do is mediation. On occasion we do something that's sort of like an arbitration, but most times people don't agree to that. But I'll give you just concrete evidence. We used to have 4 courtrooms at the board. Now we have 3 and an ADR center because we felt it was worth it to sacrifice a courtroom to have an ADR center, and it is worth it. We don't have to write an opinion, which takes a lot of work, and we get a result that the parties generally find preferable to whatever sort of justice would be meted out by the decision, because we can give people things that they otherwise would not be able to get through just a monetary judgment.
Now, if you do have an ADR resolution, that's not necessarily published, is it?
No. Generally, it's not published as far as there being an opinion or whatever, but there's 2 different ways to come out paying it. There's always a settlement agreement, and sometimes the settlement agreement says, we'll do a contract modification to add X thousand dollars to the contract and pay this to the contractor. Sometimes that's the way it works. Sometimes the contract is closed, or if you need more money that might be left on the contract, you do a judgment, which is subject to the judgment fund. So essentially you agree that they're going to stipulate to judgment in X amount of money, in which case there is a 3-judge decision with this much line saying, we enter a judgment of X thousand dollars, boom, attorney's fees to be borne by the parties, and then you sign it.
But it doesn't necessarily create a precedential issue that might be reflective of the agency's behavior in a particular circumstance.
Correct, if that's what you care about.
Sometimes.
Sure, absolutely. So there's a lot of good reasons why an agency would want to do ADR. Not only that, but of course, if you have a long-term relationship with the contractor, a lot of things can be solved by ADR. You can sort of stem the blood, the bad blood in particular. You can stop the very intrusive discovery. You can do a lot of things that are in everybody's best interests. So the board likes it for its own purposes. We know that it works very, very well for the agencies for reasons you were talking about earlier. And also works very well for the contractors because they can get paid sooner. And that makes a big difference. And it allows people to move forward with the contract if they're still performing it, which often is the case, or if they're not still performing it, but they have other contracts or other relationships with the agency, allows you to go forward. So if there's margin on a case, that is, if you think this is a case we actually have some exposure on and want to settle, well, then ADR really is something that should be front and center in your consideration. Now, as I said earlier, before I did all that preface, the key is to take it seriously. Okay? And because ADR is informal, people sometimes think, well, I can half-butt this thing, as you use another term, but you really can't. And it's deceptive that way because you think, well, it's just going to be an afternoon or 2 days maybe, and this will be easy, and we'll sort of shoot from the hip and do this thing, and that is not at all the case. There's a couple things. I mean, first of all, I can guarantee you the contractor's going to take it very seriously. So if you go in there and you don't take it seriously, all kinds of bad things will happen. One of which is they won't take you seriously. And if they don't take you seriously, you're not likely to get a very good settlement. The second thing is they're going to have incurred a lot of costs in preparing for the ADR. And if they go to this ADR, and oftentimes it means flying people to Falls Church where the board is, or something like that. Yeah. And also incurring significant legal fees because the lawyers are going to write significant briefs supporting their position on the ADR, and that's money out of their pockets. So if they do all of that, and then you sort of waltz in and say, "Ah, I'm ready to shoot from the hip," that really sends a terrible message to them, and it's disrespectful. It's also disrespectful to the board, which please don't do that. Now, if you take it seriously, though, a lot of good things will happen. One is that it'll hopefully inform the contractor that they have some litigation risk, and that, in fact, that they've got every reason to want to settle the case earlier too. One thing that generally you think about when you have a ADR is that the presentations are always the way it starts, right? Usually the contractor goes first because it's their claims. They sort of explain, here is what happened in this contract that led to the dispute, and this is why we're owed this sort of money. And that could be anywhere from half an hour to 2 hours or so, depending upon the circumstances of the case. And then after a short break, the government sort of gives its sort of take on things. And if the government take is only 10 minutes long, it doesn't really show very seriously. Now, the person.
Well, what sort of presentation material should they be bringing? Are we talking about lots of PowerPoint slides? Are we talking about hardware that we're putting on the table to show what's wrong? I mean, is it like a real show, or is it just a discussion or a oral presentation?
Kind of a hybrid.
Okay.
Good question, and it depends on the circumstances, right? If it has to do with, say, a tile or something like that on an Orion spacecraft. I have no idea if that's a contract issue or not. I just sort of pulling it out of thin air.
Yeah.
Okay. And there's something about it that would help to see it. Well, bring it. But by all means, all the sort of tools for your presentation that you otherwise use in the courtroom, you can use. Now, you're not going to have people testify or anything like that. But PowerPoint presentations, to the degree that we don't fall into the traps of PowerPoint presentations, can be helpful. Actual items can be helpful. Now, the interesting thing is the person you're presenting to is the judge, right? So the judge sits at the head of the table, and each side sort of presents to the judge, because that's ostensibly the audience. But the real audience is the other side, okay? Because the real audience is the contractor. They've probably, from the agency's point of view, they've probably heard things from their counsel. They think, yeah, I'm in great shape here. And you want to sort of tell, well, here's the government side of things, okay, and here's why we come here. And by the way, when you do this presentation, you sort of try to keep the temperature down.
Yeah.
You don't say, well, you guys did a terrible job, and this is why we're not going to give you any money or give you much money. That's not going to fly. And they're not going to say, well, yeah, I guess we're right, we did a terrible job. That's just not going to be very effective. And likewise, they're going to complain about the government a lot. It always happens. And as the government, I'm sorry, but the rules are different for you. You need to sit there and take it. but it's true.
I've explained there's a certain amount of, it's their day in court when they're doing ADR, and if they need to express emotionally what this has done to their small business, you need to sit there and let them do that, because this is their day in court if we're to resolve this thing.
Very true. You can't underscore this stuff. Now, there's all kinds of different things that go to ADR, right? You might have something with a software giant or a huge aerospace company going to ADR, and that's going to be different. It's going to be much more dollars and cents than it's going to be for the small contractor, which is going to be a whole lot more emotion and being respected. Now, I will say, though, that despite the fact that some of these really big companies should be much more bottom line oriented, emotion is important to them too. Nobody likes to be wrong or be called to be wrong. But for sure, in general, the smaller the dispute, the more sort of being heard is important to the person in the dispute. And for some of these companies, let's say it's a janitorial contract, the classic $50,000 contract, and for whatever reason, things went wrong. And the lawsuit's only for $25,000, $30,000 or some relatively small amount. But for that company, it's huge. It's everything, right? So those people need to be treated with respect. And they deserve their day in court, and they deserve our time. And again, going into these things prepared for, it's a small little thing, that does not convey what you want to convey. And not only just normatively, that is that, you're the government, you want to do the right thing. or if the contractor's watching this, you're the contractor and you want to sort of have your day in court to be recognized. If you don't prepare for it, that itself is dismissive and not likely to get you the results you want, and not going to be a good way to spend your time and help you to avoid protracted litigation. So, that's the big picture. I'll add one more thing, which is that sometimes you go into ADR for the wrong reasons. I've had some government agencies who said, well, what I want to do is, because the claim is so ridiculous, I'm going to show how ridiculous it is so the judge can tell them they deserve 0. And from there they magically think that the contractor is going to hang their head and say, oh, okay, well, I'm just going to withdraw the claim. That never happens.
Man, pop my balloon there.
Yeah, I'm sure.
Man.
So, don't go into the ADR thinking, well, they've got these excessively high expectations and we're going to diminish them. Now, they may have excessively high expectations, but if you're agreeing to an ADR, you're agreeing to it because you think you've got exposure and you're willing to bring your checkbook. If you're not willing to bring your checkbook, and it's going to be more than a de minimis amount, then you probably shouldn't waste your time and the board's time and the contractor's time in an ADR, because it's not going to succeed. They never, ever, ever are going to agree to a de minimis thing at an ADR, because they wouldn't be there if they didn't think they had a lot. I will add that sometimes one of the helpful things as an agency counsel might be that sometimes agency counsel, your job really should be to tell the contracting officer bad news, and I know most of you do. But if you need the judge to tell the contracting officer the bad news, we're happy to do that too. So sometimes having a third party and say, yeah, look, this claim there might be kind of weak on it, but this claim you got a lot of exposure, that'll happen in an ADR. And again, it's part of the process, and it's part of what happens. And you just need to know to prepare your client to hear good news and bad neuse. And I'll finally say one last bit of all this tied together is that in the tactics of you doing ADR, like I said, treating your opposing side with respect is important. So sometimes government counsel have a view that, well, I'm going to lowball this thing when I make my first offer, because that way, sure, the number is going to go up as time goes on, but if I lowball it, it's going to go up to a smaller number than if I come in at a really high number. Now, your own mediation strategies and tactics might vary. You might not want to come in with your first offer with the absolute limit of what you can possibly pay. However, if you come in with an insulting number, the other side is not going to come in and say, okay, well, I guess we'll have what we'll take. What they're going to do is they're going to dig in and say, well, why are we even here? And then it's going to be my job to tell them in the mediation, don't worry, the government always does this. I know it's disrespectful. Just lower your number by a microscopic amount, and they'll come back with a real number the next time.
Sounds like a long day.
We usually have 2 days to do these for those very reasons. But what I'll suggest to you is, think long and hard about a number you can offer in your first offer that is a legitimate number, that would not insult the other side, that would show your seriousness when you're doing mediation. That will go a long way. Other things that go a long way is if you have the contracting officer there, and if anything happened during the contract performance that, maybe we should have done this a little bit differently. Sometimes it's valuable to let the CO say that. Hey, again, the good thing is, remember, you're in a mediation, which means that the federal rules of evidence saying that things said in mediation can't be quoted against you.
Right.
So now is a great opportunity.
The power of an apology is sometimes very, very influential.
It is, and it starts things off in the right direction. And oftentimes mediations allow you to sort of do a reset. And again, if you've got an ongoing contractual relationship, having that reset can have great value, far better than maybe 6 months later having a hearing, maybe waiting for up to a year or so, hopefully not a year, but sometimes it takes a while
Yeah.
to get a decision.
Yeah.
And then, okay, well, how that decision work out? Well, let's go to the federal circuit and waiting for how long for that. That doesn't do anybody any good. So when you have the opportunity, greatly encourage you to do mediation. Again, if it's appropriate in your case. I mean, obviously, there's no jurisdiction about the issue that's being raised. Mediation is likely very helpful. If there are certain circumstances where mediation is, where everybody's in positions are intractable, it might not be helpful. But when it is helpful, treat it with as much seriousness as you would a hearing, because despite its being informal, the stakes are just as high, and the benefits in some ways are even greater than they are if you go to a hearing and prepare yourself well.
Yes. Thank you so much for helping us understand the gravity of an ADR situation and the need to prepare and to come ready to settle. It's not just a game, it's for real, and the benefits that we can get by taking this process seriously and with the gravity that it deserves. We're going to continue our talk with Judge Prouty, so we just invite you to join us again for the next episode of Between Two FARs.